Good afternoon and welcome. My name is Sophie House. I'm the Law and Policy Director at the Housing Solutions Lab. We're an interdisciplinary team based at the NYU Furman Center, and we work with small and mid-sized cities to develop and evaluate policies that advance racial equity, increase access to opportunity, and improve long-term health and well-being for residents. I'm so excited today to host this conversation about legal frameworks for addressing racial disparities in housing. We have a terrific panel, and I'll go ahead and share my screen to get us started. But we have a really terrific panel assembled here today to talk about the legal frameworks that govern cities' efforts to respond to racial disparities and to discrimination in housing in their communities, and to learn about how cities across the country are actively working on these issues. I'm going to begin with just a very short presentation. We've designed this conversation for non-lawyers, but we do have a lot of lawyers on the panel, and even the best of us are prone to lapse into lawyer speak. So I want to introduce some of the basic concepts and terms that we'll be using today. This will be a very brief introduction to a complex subject. We will, of course, have time for questions later on, and we'll follow up with many resources for further reading after the panel. So as a starting point, we know from our work that many cities are working hard across the country to address racial disparities in housing and to redress the harms of discrimination. But when it comes to incorporating racial considerations into policymaking, local governments sometimes face legal constraints under the Constitution, the Fair Housing Act, and sometimes state law. So this presentation will provide just a very brief introduction to the Constitutional and Fair Housing Act frameworks. So we'll start with the Constitution. The Equal Protection Clause of the 14th Amendment prohibits state and local governments from denying the equal protection of the laws to any person. So broadly, this means that policies that distinguish among groups for benefits or burdens can be subject to legal challenges. Courts distinguish between what are often referred to as race-neutral and race-conscious programs or policies. Race-neutral policies don't draw explicit distinctions based on race. Courts apply a standard of review known as rational basis to these kinds of policies. And all we really need to know today is that this is a much easier standard for governments to satisfy when their programs are challenged than what's called strict scrutiny, which we'll get to in a minute. Race conscious is a term that refers to policies that bestow benefits or impose burdens based on race or are motivated by a racially discriminatory intent. And courts review challenges to those policies under a more demanding standard known as strict scrutiny. I'll just briefly talk about what strict scrutiny entails. So this is a standard that courts apply to challenges to race-conscious policies, even policies designed to benefit marginalized groups. Governments must provide substantial evidence that a policy or program advances a compelling government interest using methods narrowly tailored to achieve that interest. In the housing context, the relevant interest that courts have recognized is that a government has a compelling interest in redressing its own past discrimination, not in redressing discrimination by another level of government or discrimination by society writ large, but their own violations of constitutional or civil rights law. Narrow tailoring requires that a policy be designed with precision to deliver relief to the targeted group, and must be a last resort after race-neutral approaches have been tried or rigorously considered. And this is a much higher bar for local governments to clear. Case law on the Fair Housing Act in this area is less developed, but it also constrains local governments' abilities in some contexts to engage in race-conscious policymaking. The Fair Housing Act applies to both state and private actors and makes it unlawful to refuse to sell a rent, to discriminate in advertising, or otherwise make unavailable or deny housing on the basis of race or other protected statuses. And just like under the Constitution, courts apply the same rigorous scrutiny to policies designed to promote integration or to remedy racial disparities as they do to policies that use race as an exclusionary mechanism. I'm happy to be in touch about these questions. There are many unsettled questions in this area of the law, and changes in Supreme Court composition make the future of the doctrine especially unclear. However, it's unlikely to become friendlier to race-conscious policymaking, which makes it all the more important for cities to understand the risks in the landscape, in the legal landscape, which is the reason that we are here today. With that, I will introduce our fantastic panel, starting with Professor Ala T. Johnson. Ala T. Johnson is the Jerome B. Sherman Professor of Law at Columbia Law School, where she teaches and writes about fair housing, employment, civil rights, democracy, administrative law, civil procedure, and inequality in the United States. In 2021, President Joseph S. Biden appointed Professor Johnson to the Presidential Commission on the Supreme Court. In 2017, Professor Johnson was elected a member of the American Law Institute, and in 2016, she was doubly honored with the law school's Willis L. M. Reese Prize for Excellence in Teaching and Columbia University's Presidential Award for Outstanding Teaching. Kristen Mon serves as the Director of Housing Development and Incentives for the Tulsa Authority for Economic Opportunity, leading the implementation of the City of Tulsa's affordable housing strategy through affordable housing development and landlord incentive programs. She previously worked on the affordable housing strategy as the housing coordinator for the mayor's office. Before returning to Tulsa, Kristen served as an attorney for Kansas Legal Services, specializing in public interest law areas including housing, consumer mortgage foreclosure prevention, community development, and disability. As a native Tulsan, she has been happy to return home to support equitable economic and community development in Tulsa. Finally, Greg Miao is a senior attorney at Change Lab Solutions, where he works on legal issues related to healthy housing, municipal law, preemption, planning, and environmental health. Prior to joining Change Lab Solutions, he worked on regionalizing municipal services in the greater Boston region and represented several Massachusetts communities as a municipal attorney. Greg graduated from St. Lawrence University and holds a JD from Case Western Reserve University, as well as a master's degree in urban and regional policy from Northeastern University. And a couple of housekeeping notes. You can use the Q&A function to ask questions. Today's event is being recorded, and as I said, we'll circulate some additional reading materials as well as a recording of this panel discussion to attendees after the event. And with that, we can get started. So thank you all again for being here today. And Ala T, I want to start with you. Just thinking about the, sort of very fly overview that I've given us some of these legal questions, and of course, all of your work in this area. I'm curious about what you see as the most significant constraints on cities' abilities to address racial disparities in housing or redress the harms of discrimination, or just what you would add to this kind of overview of the doctrine as we sort of ground ourselves in this area of the law.
Yeah, thank you. Thank you for having me on this panel. And thanks for that overview. So I thought you did a really good job of laying out the doctrinal framework. And I just wanted to emphasize a few additional points. I mean, I think they were there in your analysis, but just to create some bit of emphasis on them. And one is that if you don't rely on racial classifications, explicit racial classifications, as a general matter, it shouldn't trigger strict scrutiny, okay? And then a second thing, I mean, relatedly, is just this term race neutral. I think we'll probably investigate how contested it is, particularly in housing. You can think about whether any policy, just because it isn't explicit on its face, might have disparate effects and an embedded history. It's an increasingly contested term, but one can remedy a lot of racial harm without using classifications. And so these are important points to think about. So there are doctrinal limitations, but they also invite possibilities for what states and localities can do. I can say a bit more, just some points to think about. If the theme is how state and local governments can really think about remedying racial harm and designing their systems in a forward-looking way that avoid replicating patterns of historic discrimination or generating new forms of inequity along the dimension of race. I think in terms of a first step for any kind of reparative action, it might be to do an audit of one's own practices in the state and local community. Things like the history of racially restrictive covenants, zoning, denials of municipal services, failures to enforce housing laws, appraisal practices. And if, depending on the gradation of remedy you're using and how race conscious it is, you might have to make something like an administrative record on that. But even if you're not going to create an administrative record, it's a good way of building a record for a whole community to understand about the very specific practices and how they linger on until today. And then a second thing is in designing forward-looking programs, so programs that are just that you're doing right now. It could be anything with regard to your housing. So if you're thinking about how to create a priority list in terms of who has access to shelters, you can do an audit. You can think about what are the potential disparate impacts of what you are doing. So after doing that, there might be a question of what kind of action. And right now, the law is that you can be race conscious, okay? And this is not an explicit classification, but racially aware in order to remedy discrimination that you have identified and that you as a state and locality have contributed to causing. I think the thing that states and local governments should be aware of is that right now, mostly out of cases that are being generated in the school area, everything from the Harvard UNC case to cases involving screened schools and K through 12 to remedies for Black farmers and loan denials, that there is a motivated interest in moving away from current doctrine, which allows some use of race conscious remedies to a regime in which remedies, whether they're race neutral or race conscious, are not permitted. So I'll stop there for the moment. I can say more.
Thank you. Yes, I think there are a lot of points there that we'll delve into throughout this conversation. But that's those are all really terrific points. And I appreciate too you're pointing out. We're the boundaries of the as we're sort of the reason we're trying to outline some of the parameters of this doctrine is that those are is to give cities a sense of the spaces in which they can work as well, and not just what will trigger, not just what will either trigger legal challenges, but be especially vulnerable, but what are all of the different things that cities can do. So I want to move over to Greg now briefly. So Greg, you have represented local governments as an attorney, and now you work with many cities across the country. And I'm interested in hearing about which aspects of the doctrine here create the most confusion or concern for local policymakers.
Sure, and thanks, Sophie, and again, thank you all for having me with you today. I don't want to be glib and say all of it, but it's a little bit all of it, and I think it's because of all of the different actors that are sort of influencing and talking to local government when these questions come up. So I think there's a strong interest at the community level, and we often hear from advocacy groups and communities, what can we do to help remedy the disparities that we see? And I think a lot of the framing and where a lot of this comes from is that we see really inequitable health outcomes or just disparities in access to resources and access to opportunity, and there's a strong desire to remedy that. And so that I just want to sort of call out that sort of that impetus doesn't always mesh well with the legal doctrine that we have, which begins with the compelling government interest limitation, right? So oftentimes what we're seeing are cumulative impacts on our communities, right? So, there's been racist policymaking and decision making that's happened at all levels of government for a very long period of time. And so what can any one level of government do, being restricted to sort of remedying its own past action, is the first sort of question that I think we are always grappling with when we're helping communities, or when people come in. We have to sort of talk, as a municipal attorney, you would sort of analyze and say, I really appreciate where we're coming from. Have we identified, or have we gone through the audit process or examined our own history to understand what we, sort of parameters we're going to be working within in terms of, our past decision making. So I think that's a big one. The other one I want to call out, obviously, is almost everything to do with the narrowly tailored requirement. And again, I don't mean to be glib. It's just that the impetus for government is often to try to find the most direct and simplest and easiest solution to any problem. And almost all of the things or the strategies that we might utilize to do that run afoul of the narrowly tailored requirement, right? So just for example, quota systems, right? The way that, or the way the statistics that we're utilizing to justify what we're doing, it's really easy to look at population-based statistics and say, hey, there are disparities. And the courts want us to go one step beyond that and say, hey, how have our past actions, or what's the causal connection between what we, government have done and those disparate outcomes. Similarly, the use of any set hard criteria with quotas have been really, it's a much easier to implement from a policymaking standpoint. It's easy for me to think of how could I write a law or write a program that would satisfy that criteria, which immediately runs afoul of the requirements sort of set by the Supreme Court. So I think there's often this tension that is coming from sort of the strong desire to take action, and then the the nuance with which we have to approach it. And I think oftentimes, it's the last thing anyone wants to hear, which is, hey, let's spend another 2 years to go back and do the, work with an institution or work with someone who can help us audit, our own history of policymaking, so that we can really begin this in a manner that will satisfy the criteria of the doctrine.
Thank you, Greg. That's really helpful. That's a really helpful way of thinking about how some of these doctrinal requirements sort of, when they're overlaid onto the exigencies and practicalities of local policymaking, often, just the challenges of bringing those two together. So really appreciate that. And I'm excited now to hear from Kristen, who is, really in the field doing this work right now. And so, Kristen, could you just tell us a little bit about the context in which you're working in Tulsa, and in particular, what are some of the most pressing racial inequities in housing that you're confronting in Tulsa today? And we've talked a little bit about, I can see we already have a question in the chat about these processes by which cities look backwards at their own histories of discrimination. And I would love to hear about how you and your colleagues think about those disparities in Tulsa's unique and kind of grave historical context.
Absolutely. So the city of Tulsa, like everywhere else, has been experiencing a housing crisis since long before the COVID-19 pandemic. We have the 11th highest eviction rate in the country, according to Eviction Lab. And 46% of our renters are cost burdened, meaning that they spend more than 30% of their income on housing costs. As we look at those housing issues, we see that our BIPOC communities experience them at a disproportionate rate. So Tulsa is a resilient city, and we put out our quality indicator reports every year. And when we looked at this year's results, we saw that the eviction rate in non-white majority neighborhoods is 40% higher than it is in white majority neighborhoods. So we know that that eviction, that 11th highest rate, is disproportionately experienced by our BIPOC communities. When those communities experience eviction, they in turn have greater barriers to accessing safe, quality, and especially affordable housing opportunities, perpetuating that cycle of the cost burden renter and denying them access to opportunities for home buying and intergenerational wealth building. So then we look at one of our other demographics and see that white Tulsans are twice as likely to own a home compared to Black Tulsans. Each one of these systems feeds into the other, and it really perpetuates that disparate impact that we see. So we definitely center racial equity when thinking about our housing work, and understanding how work we do on eviction or homelessness prevention or the development of affordable housing opportunities in turn impacts work that we want to do in home ownership and intergenerational wealth building. But as we center racial equity, especially with the historical context, I will say something that the city of Tulsa has struggled with in the past has definitely been community engagement and incorporating the community into that process. And one of the worst examples I give comes in following the 1921 race massacre, as the city of Tulsa was considering what programs and policies and laws do we need to implement in order to facilitate rebuilding? Well, rather than incorporate the feedback of the community that had been impacted, that had lost their homes, that had lost their businesses, one of the things the city commission adopted was an ordinance that would incorporate parts of the burn district into the official fire limits of the city of Tulsa. Now, on that face, it might seem really neutral, but the community said, if you adopt this, you will effectively prevent us from rebuilding our homes and our businesses by forcing us to meet these new standards. You're going to put us into a position where we're going to be forced to sell our property to predominantly white business owners who want to take advantage of the fact that we can't rebuild our own homes and businesses. Ultimately, the ordinance was declared illegal through the work of particularly two Black litigators. But I think that that is one of the most egregious examples of showing how historically, when you don't incorporate the input and the feedback of the community, then the solutions, the programs, and the policies you adopt don't meet their needs and can just worsen the disparate impact. So in terms of the work that we do at TEO as a community and economic development organization, we've really prioritized that community engagement piece, the input, design, and feedback loop. An example of that would be the work we're doing on the Kirkpatrick Heights and Greenwood Master Plan. And that is really focused on creating a framework for the redevelopment of 56 acres of publicly owned property in North Tulsa. And housing has been a significant part of that discussion, really led by the community, what they want to see in terms of housing development and home ownership opportunities. And again, creating those opportunities for intergenerational wealth building. I really have to highlight the incredible work done by my colleague, Damari Myers, in ensuring that we really do implement that input opportunity and multiple opportunities for engagement, where the community says, this is what we want housing to look like. This is what we want racial equity to look like in housing in our community, which we take back to the design process. And once that initial draft of the master plan is complete, we then go back to the community for feedback. So just as we really think about what does housing equity mean, or what does racial equity mean in housing in Tulsa, I think that how we've chosen to approach it is focused on what the community wants to see and how then we can bring our technical expertise to put that into implementation.
Thank you so much, Kristen. And I'm looking forward to it in a moment, coming back to you with even more questions about some of those programs and community engagement as well, which is, which is both a high priority and a big challenge for all of the cities that we work with in their efforts to, design and implement equitable housing policies. So thank you for bringing that to the forefront of this conversation. I just want to, we zoom in, zoom out, zoom back in, but having, talked about some, after doing this sort of zoom in on Tulsa, I want to just zoom out for a moment to think about housing inequities and disparities sort of writ large. We're coming up on, and probably many people on this call have been on like a full month of Fair Housing Month programming, but we're almost at the end of Fair Housing Month. And Alati, I'm wondering if you could just sort of help kind of ground us again in an understanding of racial disparity. It's a little kind of a behemoth of a question, but feel free to make it your own. But in some of the racial disparities in housing that have proven most intractable since the Fair Housing Act was passed, and why maybe some of those have been so challenging to address.
Yeah. I mean, so I'd say on a number of dimensions, I always think it's important to celebrate the successes of the Fair Housing Act, and because we do spend a lot of time focusing on the limitations. I mean, just to move from a regime where you didn't have that kind of federal protection against racial discrimination initially, and then expanding to other categories over time to the point where it also includes disability and sex, sexual orientation, and gender identity, if you import the Bostock ruling in the Title VII fair employment context to the housing context. I mean, so this is a very powerful and important act in ensuring access to purchasing and renting properties. But in terms of what I see as some of the intractable, just to name a few, just one is just on the anti-discrimination front. It's always really striking that when audit studies are done, this is a different kind of audit, like they send out testers in different housing markets around discrimination, that it continues to be quite pervasive. I mean, and in categories that people would think are that people don't blatantly discriminate against anymore. So just on the discrimination prong, you think about racial discrimination, some of the last studies I saw was that more than half of the time there could be discrimination in terms of outright denial, or there could be steering. So it's still quite a pervasive practice, and it's really hard to detect, especially in the rental housing market, for people who experience it. And so there's a kind of gap between the kind of discrimination that you experience and the prevalence of it, and the ability to remedy it through complaint systems. And I think it's also important, one of the things that I always say is that in some other regimes of enforcement, we have treble damages. You get 3 times the number of damages as the harm you experience. I think that's something that should be there for the Fair Housing Act in order to incentivize more cases, and when they're remedied, to have a higher penalty. So that continues to be a problem. But I just want to mention really briefly some others that really link to what Kristen was saying, which is, I mean, one is that quite clearly the issues of affordability and people who are unhoused, cost burdens, I mean, are the major housing problem that are reported. There's a connection between those. Well, first of all, there's a racial disparity, as Kristen pointed out, in all of those different categories. And so that's important for states and localities to look at. But there's also a connection between that and questions around segregation and inclusive practices. And so I think of the continued rates of segregation And it's different across regions, but the persistence of high levels of discrimination, particularly black-white segregation, the fact that we don't have regional policies that really encourage jurisdictions to take a fair share of affordable housing, I think that would deal with economic segregation and provide more access to housing, and the related issue of single family zoning. And the last thing I'd mention, because this is something also that Kristen touched on, but is the home ownership gap and the resulting wealth gap. And there's been a lot, of course, through the years written about that, but in particular in the last 2 years, there's some great reports. The National Association of Real Estate Brokers actually had a report on strategies to reduce it, and Brookings and Urban Institute and Furman Center do a lot of work in this area. But everything from financing to appraisal continue to suffer from discrimination, and even outside of discrimination, just the legacies and the disparate impact of employment and other kinds of and health insurance and things like that continue to contribute to this gap. So those are a few that I would mention.
Thank you.
Not to overwhelm everyone with the degree of the problem.
No, I think that we're you've done an amazing job, synthesizing many decades of housing discrimination and inequity across 50 states in 2.5 minutes. So we see where all those teaching awards come from. Thank you. So Kristen, to come back to you, you work on housing and racial equity under not only the Constitutional and Fair Housing Act regimes that we've talked about so far, but also under several forms of state preemption in Oklahoma. Could you tell us about some of those, the ones that sort of affect your work the most kind of day to day, how they affect housing policymaking in Tulsa, and then would love to hear, just hear a little bit more too about some of the programs or policies that you've created within those constraints that are advancing racial equity locally.
Absolutely. So we have several preemptions that have created some unique challenges in the city of Tulsa around housing. Briefly, I would say one that has created particular challenges around housing quality. We have a statutory preemption that prevents us from requiring the registration of real property as a municipality. What that functionally does is prevents us from creating a rental registry or requiring the registration of rental property. So we cannot do proactive rental inspections. What this also creates a challenge with is Oklahoma is one of 7 states that does not have an anti-retaliation law. What that means is that if a tenant reports an unsafe housing condition to code enforcement, whether working in neighborhoods or the Tulsa Health Department, and the landlord finds out, they can and do retaliate against them. That creates some particular, there is definitely issues with that because of a lack of affordable housing supply. So we have tenants who will endure incredibly unsafe conditions. We just saw last year a complex called Vista Shadow Mountain that lost its certificate of occupancy due to the severity of the unsafe conditions. And there were 100 households living there at that time. And I got asked, why would they continue to live there? I said, there wasn't somewhere else for them to go. And I got asked, why didn't they report the unsafe conditions? I said, because they can and would be retaliated against. And when given a choice between living in an apartment that literally had no walls, no walls, they chose that because the alternative was no roof. So we have very unique challenges there. When it comes to issues of racial equity, I would say our most significant preemption is constitutional, and that is State Question 759, which added an amendment to the Oklahoma State Constitution prohibiting any preference in public contracting based on race or sex. So to give you an example of that impact, you heard me mention that we have a racial disparity in homeownership rates. Well, the most obvious way to address that would be, well, let's create a homeownership program focused on helping Black households to become first-time homeowners. I would not be able to create a program or fund a program that does that because it would have an explicit preference when it came to race. So one of the most common ways that we navigate that, and you see other places do that as well, is using a geographic approach and targeting non-white majority census tracts. That can be really effective in some ways, and it can have some negatives. So we've mentioned the segregation, that creating programs that have that geographic focus run the risk of just reinforcing racial segregation that has been created through policies like redlining. In our attempts to center racial equity and lift up communities that have experienced disparate impact, the last thing we want to do is just reinforce the lines that were drawn through racial inequity. So how we have thought about it goes back to, again, that community focus. We hear about the barriers that communities, in particular, communities of color, experience when trying to access housing resources, but also business resources and funding that they would use in order to improve housing conditions in their community. So one of the unique tools that we launched in 2021 is our Affordable Housing Trust Fund. So the Affordable Housing Trust Fund is a citywide fund for the production and preservation of affordable housing. We do that through loans for affordable housing development and grants to create home buyer assistance programs, landlord incentive programs, and rental assistance programs. I'm going to highlight, I could spend the next hour talking to you about all these different programs.
So could we? But we actually cannot. But
we'll talk about the loan. So as we designed this loan process, again, this goes back to the input, design, feedback loop. When we launched this loan program, we really wanted to make sure that we had created a low barrier resource, that we provide zero interest loans for the production and preservation of affordable housing. And we consistently heard from local developers, it was really hard to access some of those traditional resources, just what was required up front in that pre-development phase. The level of capital that was required was keeping smaller developers, and particularly developers of color, from pursuing those opportunities. We said, let's design a process that doesn't do that. At the same time, it's not perfect. Once we launched, we immediately got feedback that said, hey, you created a barrier. And I said, well, what did we do? And what we had done is we required developers to tell us about their years of experience, and then we weighted that in the scoring matrix. And it was explained to us that we had created a barrier for our BIPOC developers because many of them were newer businesses, and it prioritized those who had access to partnerships that had 20 plus years experience. So 6 months later, we would announce an updated policy with multiple changes, but that was one, is we made sure to remove that from the scoring matrix so that we didn't weight it and we didn't incorporate a barrier that would exclude developers of color. And so something I think about a lot with that, if you haven't read Know Your Price by Dr. Andre Perry, it's one of my favorite books to recommend. And working in economic development, I frequently highlight a line he has in there that says there are often two tracks for economic development. One for everybody who knows and has access, and then everybody else. And it's definitely a goal for us that there is one access for economic development, that everybody is able to come after these resources. So the first loan ever made through the Affordable Housing Trust Fund was to a Black-owned business for the development of 10 single-family homes, and focusing on some infill rehab. And those will be rented over the next 15 years to households with Section 8 housing choice vouchers. And I think that really speaks to how we wanted to design this process, that if we can't give preference. If we can't do that with public contracting, what can we do to at least remove the barriers and create accessibility? I would say, just from my experience as someone in public service, I want to emphasize, you will never get it right the first time, ever. You just can't. So incorporating that input, design, and feedback loop to continue to be willing to change and amend and develop a program to ensure that you remove barriers that may have been unintentionally created, I think is incredibly important when it comes to not just centering racial equity, but creating truly meaningful impact. I will highlight one more, just because I want to highlight our partner at TEDC Creative Capital. They are a local CDFI. One of the some of the feedback we got for our BIPOC developers who wanted to create affordable housing opportunities is a lack of education around development, and particularly affordable housing. It can be tricky, it can be complicated, and wanting to pursue funding opportunities from traditional sources like financial institutions, knowing how to put together a pro forma, knowing how to put together a budget and present it in a way that makes that funding and capital accessible can be a challenge. And so they created the Rebuild Tulsa Developer Academy that has just completed its first cohort and is accepting applications for the next cohort in June. And I just have to commend them on their tremendous work, again, being a partner who says, what are the barriers that people are experiencing that if we could remove, we could achieve true racial equity in our housing work? And they did a tremendous job really building out that program.
Thank you. There's so much rich material there for all of the, I know we have many local policymakers and their partners in the audience today. And it's, yeah, it's just, there's nothing more helpful or more powerful, I think, than seeing someone who's doing the work, seeing what they've tried, where they've adjusted. So thank you really again for sharing all of your experience with us today. Greg, since you've had the chance to work with lots of different local governments, I'm wondering if you if there are any other sort of examples of cities taking innovative approaches elsewhere in the country that you would want to highlight. And then I'll have a specific question for you about the kind of unique approach taken by Evanston, the city of Evanston. Oh, but first, we will be opening up the conversation to audience questions shortly. So you have about 7 more minutes to type questions into the Q&A box. So Greg, yes, to Greg with questions about what other cities are doing.
Sure. So there's a lot I think that other cities are doing, and I know that we've got limited time, so I'll throw a few out there. You know, I think that Seattle's Race and Social Justice Initiative is a really strong sort of example of a large city taking a really firm look and establishing a pretty robust public process to re-examine its history and the history of sort of policy-making decisions that have led to disparate impacts and disparate outcomes, and to audit some of those policies for which of those are still in existence and are still continuing to perpetuate some of these inequities. And so it's a great process, and I think a great example of a city that can both identify continuing tension points and as well as sort of start creating that evidentiary basis that's really necessary for taking Evanston style action on sort of direct race conscious reparation style programs. I think another one, just to highlight, Portland's Right to Return. Again, addressing it, as I saw it mentioned in the questions, I think it's a really interesting example of a sort of you know, race neutral but geography based policy that has such an overlay, particularly since the effects of redlining and segregation led to such geographic separation or segregation, you know, in the sort of urban renewal era. So I think those are two good examples. The last one I'll highlight is that I think there are some communities in California that are starting to utilize some, what I would say are, I don't have the right terminology for it, but somewhat race conscious aggregate criteria in their decision-making processes. So Cal EnviroScreen has a environmental justice impact tool that creates sort of some risk analyses for different communities based on all sorts of geographic and sort of land use aspects, but also it includes within it some race conscious aspects of who are the communities that are being most impacted, what are the different exposure or the differential exposures between different communities. And we're seeing that sort of a lot of people utilizing more aggregate criteria of where sort of race is only one aspect, and they're not necessarily assigned a strict score metric within their decision-making frameworks for how are they going to prioritize sort of the use of government resources. And so I'll stop there. There's many more out there, but I think that those are some good examples. Actually, last one, shout out to Desegregate Connecticut, because I think they're doing great work as well.
It's my home state. Great. And so Greg, I'm one program that has received a lot of attention for taking a pretty different approach is the city of Evanston, which has enacted a local reparations program. And its first component is a restorative housing program that provides in various forms financial assistance with home ownership for Black residents who experienced housing discrimination in Evanston and for their descendants. Could you just walk us through a little bit of how that program sort of fits with, fits within the legal frameworks that we've been discussing?
Sure. So before I do, I just want to mention that Evanston's program has, I'm not an expert on Evanston's program, so I want to disclaim that a little bit. But I also want to acknowledge that it was the result of many years of work and having gone through the process of examining sort of its own historical policymaking decisions that contributed to disparate housing impacts and outcomes. And that's really where it starts. So in order to satisfy the criteria of the legal framework, a city has to understand what its own impact was. And so Evanston went through and did that. And to sort of provide some context of like what that means, there's a 77-page report that was, I think, published, and I think it took the better part of almost 2 years, I would guess, for them to pull that together, outlining sort of a whole range of sort of both positive or sort of intentional policy decisions that the city made that led to disparate outcomes, as well as sort of passive participation in a racist system that also sort of cumulatively led to disparate housing impacts. So, for example, they cite the 1921 ordinance that tacitly served as an effort to segregate the city by race, as well as sort of 1940s home policies around home demolition, which were sort of disparately utilized within Black communities, as well as then sort of tracking the rate of Black home ownership within the city as a result, or sort of tracking that in parallel to what the decision-making process was within Evanston. So creating a really robust connection between both like affirmative actions taken by the city and the impact it had on the Black community in the city, right? That's sort of what's required. So they did that. And they also talked a little bit about sort of their passive participation in other forms of discrimination, right? Including repeating decisions to give, grant building permits to Northwestern, despite the university's refusal to allow Black students to live in campus housing at that time. And so, establishing some of those secondary arguments in support of why this program is necessary. So they created the evidence base, and then the next thing they did is they made it narrowly targeted. Right, so they sort of talked a little bit about what are the failures of other types of programs to address this. They identified the eligible population, giving it a sort of a time limited perspective, right? So residents, Black residents who lived within the community during, I think, sometime between the 1920s and 1960s. So during the time when most of the history of the city's racist policymaking or actions took place. And then they've tied the remedy directly to the type of harms that were experienced, right? So these were policies that were enacting housing harms. We now have it's a sort of housing access and grant program for first-time ownership, but also housing repair and a few other things. So it's again tied to the type of harm that was experienced as a result of the actions that the city took. So that's how you thread the needle. And I'll stop there.
Thank you. I appreciate that really incisive analysis. So we are, I can't believe it, but coming right up on towards the end of our discussion. So we have a couple of questions from the audience, and time permitting at the end, I'll do a more kind of general go around, but I want to make sure we get to some of these great questions that have come in as well. So just starting with Ality, we've had a question come in about the use of unprotected sort of non-racial characteristics as proxies for race in designing and implementing policies and practices to advance racial equity in housing. Question says, from a legal perspective, are there risks in associating such proxies with explicit racial equity goals? For example, can opponents claim that these are mere proxies for race and therefore subject to Equal Protection or Fair Housing Act challenges? From a policy and messaging perspective, how does this strategy otherwise weaken or undermine the legitimacy of racial equity goals, and how can we think about getting around those challenges?
So, yeah, hopefully you can hear me. Thanks, Solomon Green, for that question.
A friendly anonymous Solomon Green.
I think maybe a way to think about it, I'm not sure this is going to come out as crisply as I want, but is that I wouldn't, if you're trying to do an action where you want to create an explicit racial classification, and then you decide, hey, I'm not going to create an explicit racial classification because that violates the law. I'm going to use something that proxies for that. You could still be in legally dubious territory. And I don't think proxy is a good way to talk or think about this. And Greg may want to jump in on this too. Yeah. I think that at that point, you should be thinking broadly about the kinds of barriers specific communities are facing. And some of those may overlap race and class. They may not hit your group perfectly, but if you're actually doing some sort of ongoing data collection, audits of your practices, you should be able to identify a range of things that would make a difference. I think that it's unfortunate. I mean, it's set up just the way Greg suggested, that you should be able to do something more direct under the law. But I think that you could do, that's not the way it is. I think you can get at it. I wouldn't not even call it a proxy. I just wouldn't even think of the remedy as a kind of proxy. I would think of it as trying to get at the underlying equities through different forms of interventions that don't require explicit racial classifications. And then just something to say about the framing of that. It is still okay under the law to say, I care about racial inequities. But there are groups that are trying to make it not okay. That's what the Thomas Jefferson case is, to me, functionally about. Maybe there's some space between the Thomas Jefferson case and this question, which is this case challenging practices at a high school that went to a neighborhood-based way of getting students into a very specialized high school. And they just said, after Floyd, we care about the racial diversity in the school. So I'm not going to suggest that there aren't any legal risks, but it's not the law right now that you can't even say that you care about racial remedy. We still care about that in America, supposedly. So I want to keep that the law.
Thanks, Lottie. Greg, do you?
And by the way, look, can I just add one thing? It's also built into the Fair Housing Act. Avoidance of disparate impact, affirmatively furthering fair housing, and that gets at another question that was asked. And the Fair Housing Act is a constitutional exercise of Congress's power to enforce the 13th and 14th Amendment.
Yeah, just really quickly, I appreciated Lottie's sort of distinction between the types of programs and types of responses. And that's all I wanted to sort of reinforce, is that I really think from a local government perspective, I think there's a really important aspect of very explicitly and outwardly acknowledging past racist policymaking and identifying solutions and remedies that are designed to address the past harms that the government made. I think there's all sorts of really important reasons for that. I think that is one specific style or type of reparations. And then I think the framing that Aladi was providing around sort of addressing directing resources and trying to address disparities and current outcomes and health and opportunity and education. I think that those don't necessarily need to have. There's a lot of evidence that we need to provide to sort of support them, but they don't need to have that same. The audience doesn't necessarily need to be the same, and then the legal justifications don't need to be quite as strict. And so I think it's good to conceptualize in the sort of what the government's doing and what it's trying to accomplish, to sort of separate those two out a little bit, and then maybe it will make for a little bit easier decision making or sort of easier implementation of those different policies when we're not trying to conflate them a little bit.
Okay, thank you. And really time for, I think, just one more question and response. So Kristen, I want to end with you. If there's anything you haven't had a chance to say, please, take 2 minutes to do it. But also, we've had quite a few questions about community engagement, and you obviously spoke to how robust community engagement helps you sort of go through a trial and error process in policymaking. But I'm curious about the trial and error maybe within community engagement itself, and how you've arrived at some of the practices that you rely on. So feel free to take that or anything else. 2 minutes. Here we go.
Well, I would say from a community engagement standpoint, that's something that we're growing. We've been really fortunate to have Jonathan Butler join us as our new SVP of Community Development. But I think that something that we have really found is creating multiple opportunities for engagement throughout the process. When I say input, design, feedback, it's a loop. It just starts over. You're not done. You have to keep creating those opportunities. Understanding that you have to do it in different ways. You can't just hold the same meeting at the same place every weekday night at 5. That doesn't create opportunities for everyone. I think being truly receptive to it, something I heard Jonathan say today is it's okay to just listen. You don't have to have a retort for everything. Sometimes you can just take on board what people need to share. And I think finally is really incorporating what lived experience means. I've talked a lot about how we need to understand that the policies and programs are living things that people engage with. And just because you don't necessarily see how it's impacting someone else is living it. And they're trying to tell you, hey, you created a barrier. Hey, this is a problem. And really treating them as the experts We can bring all sorts of technical expertise, but they're the experts on their lived experience, and really honoring that and incorporating it in. So I would say that those are kind of our key thoughts on our community engagement process. And if you want an example of the incredible work Damari Myers is doing as part of the Kirkpatrick Heights Greenwood Master Plan, go to ourlegacytulsa.org. You will see the types of events he's created, the opportunities for engagement, the diversity of that. And I really do just love to highlight what he has done there to start incorporating community feedback and input into what will not just be that master plan, but also what housing will look like in North Tulsa.
Terrific. Thank you. Well, I've seen we've had many more questions than we'll be able to answer. I hope some of the resources that we've posted in the chat will be helpful to you. We hosted another fascinating conversation in November with some city leaders who are working to understand and respond to their own histories of discrimination. And I hope that panel, the recording of that panel and some writing we did afterwards will be helpful to you. We've also released a policy brief outlining some of these legal considerations in more depth that you received along with your invitation to this event. So we look forward to continuing the conversation. I want to say first and foremost, thank you so much to Alati, Kristen, and Greg for just a wonderful conversation. Thank you to the Robert Wood Johnson Foundation and to JP Morgan Chase & Co. for their support of the lab's work on this issue. And thank you to all of the amazing staff at the lab and the Furman Center who made this event possible, but especially to Kayla Merriweather, Charlie McNally, and Jess Wunsch. And with that, we say goodbye.